So welcome back. Welcome back. As I said, we are going to discuss a very simple but important aspect of procedure, withdrawal and discontinuance, under 17. So we are supposed to understand the conceptual basis of withdrawal and discontinuance, and be able to distinguish between discontinuance with leave and discontinuance without leave. And we should understand the consequences of discontinuance on real litigation. When you discontinue and then you decide to come again, what is the effect of the discontinuance on that? Then we should be able to appreciate the relationship between discontinuance and then the estoppel. And of course, we should also understand the impact of discontinuous withdrawal on counterclaim and also appeal. Yeah, so first of all, when we are talking about withdrawal and discontinuance, we are talking about three related principles of civil justice. Parte autonomy, that is control of a party over the case. And then the judicial supervision, what the courts actually do with respect to proceedings when they are started. And thirdly, the issue of finality of litigation, the fact that litigation should come to an end at some point. Now, before we proceed further to even look at Order 17 and discuss the nuances, I think the Supreme Court, speaking through Agnes Dordzie, in the case of Margaret Ntiriwa, I don't know if you have it in your list. The case of Ntiriwa Achiampong against Obaapayin Aba Yaa, substituted for Araba Adawoma, a decision of the Supreme Court on the 5th February 2020. She made a statement I want to quote for the beginning, then we discuss the rest. So just listen. I'll make it's available to you, or can you just download it online? Dordzie speaking. As earlier stated, the application before the trial court, which is leave to discontinue the action, falls under the 17 Rule 3 of the High Court Procedure Rule 747. The principle behind this rule, I'm still quoting here, has been considered in many decided cases in our court. The principle, simply put, is that a plaintiff, having reached a stage in an action he has brought before the court, cannot discontinue the action at will. The rule gives the court the discretion to determine the terms of the discontinuance to maintain the balance of justice between the parties. Then she referred to Pega J as he then was in a case he decided in the Saraku, the third, against Ellis and Wood families, reported in 1989 and 2009. She referred to his decision and continued as follows. Before the enactment of the 26 to 1 of LN 140A, the plaintiff's right to elect to be non-suited at any stage and still retain its option to bring a fresh action went unchallenged. Order 16 Rule 1, that is the old LN 140A, equivalent of current Order 17, has greatly curtailed that privilege. It is a complete code on the subject of discontinuing an action or withdrawing a defense. The power of the plaintiff at common law to claim a non-suit of a plaintiff in equity to dismiss his bill at his own option at any time and still retain the right to bring action was removed, unquote. Then she makes the point, Agnes Odi makes the point that Order 26 Rule 1 of LN 140A and Order 17 Rule 3 of CI 47 are in pari material. And in fact, if you look at the table of the legislation, look at the table at the beginning of Order CI 47, they have the comparison. You want to know the analogous provision in the repealed LN 140, you see it over there. So you notice that Order 26 was the equivalent of the current Order 1, the 17. And that is why you're saying that they are in pari material, meaning that they are similarly worded. And then she continued. Thus, the decision of the English Court of Appeal in the case of Fox against Star Newspaper Limited, which considered the principle behind Order 26 Rule 1, became the locus classicus on the issue. In Fox against Star Newspaper Limited case, Chitty LG explained the principle in the following words, quote, so Agnes Odi still quoting, but it's very useful, that's why I'm reading for you. The principle of the rule is plain. It is that after the proceedings have reached a certain stage, the plaintiff who has brought his adversary into court shall not be able to escape by a side door and avoid the contest. He is then no longer dominus litis, and it is for the judge to say whether the action shall be discontinued or not, and upon what terms. I think it will be a great error to construe the rule by reference to the old meaning of the term discontinuance or any mere technical sense of words. The substance of the provision is that after a stage of the action has been reached, at which the adversaries are meeting face to face, it shall only be the discretion of the judge whether the plaintiff shall be allowed to withdraw from the action so as to retain the right of bringing another action for the same subject matter. Unquote. So she quoted the English court elaboration on the rationale underlying Order 26, which is the pari material to our own Order 1, 17. And then this force against the Star newspaper was cited in the Ghanaian case of Amoako against Kwan by Oserureji, as he then was, and put it in the following way. So Dordzie still putting also that the court therefore has a wide discretion as to the terms upon which it may grant leave to a plaintiff to discontinue the action. The court, for instance, will consider all the circumstances, and if it seems just, will impose a term that no other action shall be brought. It may in like manner refuse leave to discontinue and give judgment for the defendant. As you continue. From the operation of Order 17 Rule 3, there cannot be any hard and fast rule in the exercise of the court's discretion to allow a discontinuance and deny the plaintiff liberty to reinstitute the action, as it is in the present case. The circumstances of each case will determine the orders the court will make in an application to discontinue under Order 17 until CI 47. Unquote. Yeah, so with this background, we come to discuss Order 17 on withdrawal and discontinuance. So we'll quickly read the rule, and then I will break it down further for you in the real last bit before we move on to discuss applications. So Order 17 Rule 1, a party who files an appearance in an action may withdraw the appearance at any time with the leave of the court. So we've discussed that before. Once you've entered appearance, you can withdraw it, but the court will have to permit you, but we'll come and discuss why. Then 2, except in the case of interlocutor application, the plaintiff may at any time before service of the plaintiff the defendant's defense or after the service of it, before taking other proceeding in the action, by notice in writing, wholly discontinue the action against or any of the defendants, or withdraw any part of the alleged cause of action, and thereupon the plaintiff shall pay the defendant's cost of the action, or if the action is not wholly discontinued, the cost occasioned by the withdrawal. So we're also seeing the plaintiff also has the right to also withdraw. We'll come and discuss that. Such cost shall be taxed, and the discontinuance or withdrawal shall not be a defense in any subsequent action. When we use the word tax in relation to cost in civil litigation, we're not talking about tax as in the Ghana Revenue Authority. We're talking about assessments of cost, like proving or demonstrating the various areas of cost and how the person is entitled to them, as it were. So the 74 has a whole taxation regime on costs, but we discussed that. Except as provided in this rule, the plaintiff shall not be entitled to withdraw the record or discontinue the action without leave of the court. And that is what Ladyship Agnes Dordzie GSC was reminding us. But the court may, before, during, or after the hearing or trial upon such terms as to cause, and as any other action as may be just, order the action to be discontinued or any part of the alleged cause of action to be struck out. And then we also have withdrawal by consent. An action may be withdrawn without the leave of the court at any time before trial, where all the parties produce to the registrar a written consent that the action be withdrawn. And then finally, on the 17th reform, if any subsequent action is brought before payment of the cost of a discontinued action for sale, or substantially the same cause of action, the court may, if it thinks fit, order a stay of the execution of the subsequent action until the costs are paid. Yeah, so this is the law. So having quoted the statutory framework, let us break it down. We first of all talk about the plaintiff as what we call the dominus litis. It's a concept you should know, and then it was cited by a ladyship in the opinion that I just read for you. So the plaintiff as a dominus litis, what does that mean? Dominus litis simply means that master of his action. We also come and talk about how to suppose. Let me write my Latin essay before I get there. So when we say the plaintiff at common law, traditionally is regarded as a dominus litis. What it simply means is that the plaintiff is the master of his action. When we say action, that is the case that he or she brought to court. So the plaintiff initiates the proceedings, isn't it? He defines the course of action. And then he will select his defendants. The plaintiff will choose the defendant, isn't it? Yeah. And then the plaintiff will actually frame the reliefs. He will frame the reliefs or the remedies that he's interested in. And that is why we say that he's the dominus litis. He is the master of his action. He enjoys some kind of sovereignty at the start. He will decide, all the people here, if I'm taking of information, who is going to be my defendant? I mean, she knows herself. That she will. Yes, what is it?
And this with respect to the dominus litis, we are going by that, and we are saying that the plaintiff is the master of his action, but we need to defendant. So this is what happens to where the defendants.
Yeah, so with respect to the third party procedure, yes, with respect to the third party procedure, the defendant in relation to the third party the case against the third party is also dominus litis. Yeah, because it's just like a counterclaim between the defendant counterclaim against the plaintiff. We've noted that a counterclaim is a separate or independent cause of what? Action. So, with respect to the counterclaim, the defendant is also like, as it were, the plaintiff. And also like a dominus litis, because he decided that he has a case against the plaintiff. So, what this means, or this dominus litis principle means, is that a litigant cannot be compelled to litigate. You cannot force a person if he doesn't want to do what? Litigate. Yes. And so no court can force a person to litigate. And if the person should so decline, he cannot be held in contempt of courts. So if you look at the case of the Republic against High Court Accra, as parte Asokam Engineering and Construction Ltd. 1992-93 Ghana Bar Report 264. And the Supreme Court decision. And they affirm PEGA J, sitting as additional cause decision. But despite the fact that the plaintiff or the party who start the case as a dominus litis is a master of his action, that autonomy is not absolute. It doesn't mean that you can do anything you like at all. So that is the point that we have to note. So as soon as the writ is issued and said, litigation ceases to be purely private matter. Before you go to court, it's a private matter. You are sitting in your house. You can decide who to choose as your defendant, what to ask against that person. You make all those decisions. But as soon as you get the court to seal the writ and get it issued, and it's said on the other party, you don't have total control by it. So three things occur. The court's jurisdiction is engaged, isn't it? Once the writ is issued. The defendant's legal position is affected. It's affected in the sense that if he doesn't respond, he may suffer certain things, including award of course, or even sometimes judgment in default of what? Appearance, or judgment in default of defense, that the case may be. Or he can even face contempt of what? Of court. And thirdly, public judicial resources are committed. So once you start the case, it's not just your private matter. You're using the public judicial resources, isn't it? So at that stage, litigation becomes a public concern. It's not a private matter again. And for that matter, the autonomy of the plaintiff as a dominus litis must at least yield to the defendant's right to finality. Nobody would like to be vexed more than once. Litigation is vexing, isn't it? So you like to have finality. So at least the defendant has the right to finality. The court also has a duty to prevent abuse. Abuse in terms of the judicial resources and also the right of the defendant. All those should be protected. And of course, finally, integrity of the judicial process. And that is the basis usually, especially for contempt. The majesty and authority of the court should be protected. Not just for the person of the judge, but for the institution of the justice machinery, so that the public will have confidence in it. And that is why Order 17 draws a line between two things. Discontinuance between defense, and then discontinuance after defense, or advanced stage of proceedings. So when you read Order 17, notice that you can make a withdrawal before defense has been filed, and you don't need leave. Did you see that? Good. But then after defense, you need what? You need leave. So the the case of force against a Star Newspaper Limited, which a lady against the Jones who cited in the Ghanaian case that I mentioned, actually recognize that after a certain stage, the plaintiff is no longer free to withdraw at will. So after defense have been filed, the plaintiff cannot just say that I'm no longer interested. Litigation is not a joke. It's not just set in motion the rationale of the justice against someone. And when the person is also ready to face you, you say that no, I've abandoned it. Just like that. No, it doesn't work like that. So the court must consider the fairness to the defendant. Is it fair? And why is it so? Because once issues are joined, when you say issues are joined, you understand it now. What does it mean to say that once issues are joined? From our learning of pleadings, once the pleadings are joined. Yes. Why are you the spokesperson for the class? You are the spokesperson for the class?
Self-appointed.
Self-appointed. So you have to give the energy to be answering all your questions for you. Yes, but yes, let's hear you. If the others will not talk.
My lord, it simply means that we are in disagreement, the issues.
Okay. So the issues are joined. The horns are what? A lock, as it were. And for that matter, the defendant acquires a legitimate expectation at that stage. And that is why, what is that legitimate expectation? That it's due to be resolved. Once issues are joined, yes, let's resolve it so that let's know who is right, who is wrong. And then his reputation may be vindicated, especially, let's say, defamation, as it were. So just imagine somebody will issue a defamation suit, and suddenly they even give a prominence to it. Let the media publish it. And then only to find out that the plaintiff abandoned it. Just like that. When the defendant's reputation has also been won, we put it on the line, as it were. We also talk about the fact that the court also has the duty to avoid abuse, isn't it? Yeah, to avoid the abuse of the process. And here we are looking at a situation where discontinuance may amount to abuse, in the sense that a plaintiff repeatedly files and withdraws identical claims. People can really be abusing the court process. The person will file a writ, will serve on you, then just as you are also coming, you will discontinue. In no time, after a few days, or he will bring a similar, the same, essentially the same, claim, a fresh, process against you. So that is a kind of what? Abuse. And then also, proceedings are used to harass the other party. Remember vexatious proceedings. The cause at session what? We said that Attorney General may bring proceedings with respect to vexatious litigant. Session what? At 4.5 now, which session? The cause that you mentioned, we discussed it earlier on. Do you have your course out with you? Look at it and tell me. We'll discuss it already. Again, with respect to the court's duty to check abuse, litigation should not be weaponized. Litigation should not be what? Weaponized. It should not be used as a weapon to address, if you like, some other collateral scores. But it's really about genuine dispute which need to be pursued and resolved. And again, the court must also ensure that withdrawal is not used to oppress or to do forum shopping. When we say forum shopping, we can have litigants who will initiate a matter. When they realize that, especially let's say that the Accra, the court complex, we have about 40 or so courts in there. So about 40 judges. And then you go to the second court, so we have I think about 8 or 12, about 11 circuit court, let's say in one building. So you initiate the process. And then you get to know that it's put before Judge B. He said that no, Judge B, how I know Judge B, I don't want Judge B to be the judge to adjudicate this matter. So you quickly go and you file withdrawal, as it were. And then you go and get the same process issue, hoping that it will not be put before Judge B, it will be put before Judge F. So you are doing forum shopping improperly, and that is no good. So these are the things we should have at the back of our mind. So if you look at Order 17, the public policy underlying it is basically that, yes, there's a freedom to retreat early. That is, before defense, withdrawal is what? Unilateral. Unilateral in the sense that you don't need to go to court. And at that stage, you don't have so much problem, isn't it? Issues are not really crystallized because the defendant has not filed defense. So issues are not joined. If anything at all is the appearance, which has been filed, and maybe he's paid like his initial lawyer's fee, and then the filing fees of the appearance. And again, there's a protection after engagement. After defense has been filed, the defendant has made some investment, isn't it? He has made some investment, and that investment justifies judicial control. The defendant has gone for lawyers. The defendant has actually have to organize himself or herself to put up a defense to respond to the claim, the statement of claim. And that is why the court need to come in to protect that particular interest. And that is why leave becomes necessary. And you cannot just discontinue on your own will or on your own choosing, as it were. Then the third public policy point is that there's also prevention of harassment. And how does that happen? The court may refuse liberty to bring fresh action. So sometimes when you go to court, you hear that, okay, suit strikeout has withdrawn with liberty to reapply. Meaning that you're giving you the window. If you still want to come back, you can do what? You can come back. But the court may impose costs, or the court may stay subsequent proceedings. The court may say that, well, if awarded costs against you, not until you have paid the defendant costs, you cannot bring any similar action. So therefore, if you go and bring a similar action, the defendant can come to court and say that you have not fulfilled the orders which the court made with respect to costs when you discontinued or when you withdrew the previous action. So you should not be allowed to pursue the new action you have brought. And then the final policy point is that, as you will notice, litigation consumes public resources, isn't it? So discontinuation must not waste judicial time. It must also not create multiplicity of work, proceedings. You discontinue, go and start a new case. It's when you go and start a new case. That is not good. Now, before we move on, is there a difference between discontinuance and dismissal? They're the same. If you read Mr. Kwame Tete's book, yes, are they the same? When we say an action has been dismissed, an action has been discontinued, or action has been struck out. So dismissed means that there has been adjudication. It means that the matter has been what? Adjudicated. Strike out, there's maybe some procedural breach leading to its removal. And then discontinued is voluntary cessation. The party has voluntarily what? Said that I have ceased, as it were. Now, they have implications when we are discussing a estoppel aspect of these matters later on. So as we read the rules, in terms of Order 17 Rule 2, the plaintiff may discontinue the whole action, either the whole of the case, if discontinued it, or you can discontinue part of the claim. So let's say that you have about 4 or 5 reliefs, and you think that relief C, D, and E, they are no longer important. So you want to discontinue. You can do that. And it will not mean that the whole case has come to an end. No. If only discontinue part, the other part will continue as it were. Again, in terms of Order 17, Rule 1 as we read, Order 17, Rule 2, 1 to 2, the plaintiff may also discontinue against all, either all of the defendants. So if you have, let's say, about 4 defendants, you can discontinue against all of them, or you can discontinue against some, or any of them, and leave the rest. Maybe I discontinue against second and third defendant, meaning that first and fourth defendant are still part of the case. So that is also possible. And again, the plaintiff may discontinue at any time, as we noted, before the defendant's statement of defense. But you can also discontinue after receipt of the defense, but before taking any other step in what? In the action, as it were. So you draft a simple process with the title of the case, and you just write a notice of what? Discontinuance, Order 17. And then take notice that the plaintiff hereby discontinues the action against the defendant, assuming if you are making a total discontinuance, or if you are only discontinue part, then you have to specify in the process as the case may be. And as we've noted here, you don't need to go to court to get any leave or approval. And we've explained why leave is not required at this particular stage. Now, what is the effect of discontinuance without leave? What is the legal effect? It does not determine the merits, isn't it? So, if there has been discontinuance or withdrawal, can it be raised as a judgment estoppel? Can it? Somebody said depends. Can discontinuance or withdrawal be raised in a subsequent action as a judgment estoppel? Those who say no, raise up your hands. And then those whose hands are down are the yes. And this one, there's no abstention. You belong to one camp. There's no middle ground. Yes, those who say yes, raise up your hands so that we know. Those who are saying that discontinuance or withdrawal cannot be raised as a judgment estoppel in future action or subsequent action, raise up your hand. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17. Okay. So 17 people are right. And then, because, so neither discontinuance nor withdrawal may be raised in subsequent action as well. Our judgment estoppel. It has not determined the merits of the matter. Has it determined it? Yes. It's just, you just abandon something that you started, but it's not been determined. Please look at the case of Eslifi and Anafo. Eslifi and Anafo. 1992. Eslifi and Anafo. 1992 to Ghana Law Report 654. And when you look at that case, notice that it's a very important English case called the Crown Prince. The Crown Prince, they cited the Lord Herschel's explanation of the matter. So if you look at Eslifi and Anafo, they have cited him there. And the point is made that a dismissal operates as a bar, but that requires adjudication, isn't it? But striking out or non-determination, such as discontinuance or withdrawal, does not necessarily do so, as it were. So in that case, when there has been withdrawal discontinuance, the plaintiff may institute a fresh action, provided limitation has not expired. So if you discontinue, for example, and then the limitation expired, you cannot say that you had gone to court earlier on. No. I don't know if you get it. So let's suppose that you have a simple contract under Limitations Act. How many years? Simple contract under Limitations Act. How many years? 6 years. Then what about the tort? Negligence and stuff. How many years? 3 years. Okay. And then the land. 12 years. So a lot of you all have lands here. How you came out? Okay, so if you discontinue, and then before you came back, the limitation has run out. It has run out. So if you are not sure, instead of discontinue, you could have remained. And if you have to do amendment, you do what? You do it. Because that one, the case will be pending, as it were. Yes.
Yeah, you mentioned that continuing with litigation.
Yes.
So that if you are continuing with litigation and come back, you can discontinue without limits. What's the legal limit of it?
Without?
You are continuing without limits. Doesn't mean you can come back or you can come back.
Good. So it gives rise to controversy. So we used to have like two schools of thoughts, which says that if you don't indicate our liberty to come back, that means that you shut yourself. But if you indicate that there's a liberty, then you haven't shut yourself. But if you look at the rule itself, the rule itself is what is quite silent, isn't it? So the 17 that we read is quite silent, except that the court has the power in terms of policing the withdrawal and discontinuance. Now, when the court, especially when they come with the leave, like with the court, then the court can indicate either with liberty or with what? With no liberty, or impose conditions and say that maybe pay costs. Not until the cost is paid. You cannot bring any fresh what? Action. So assuming that is done, then the condition precedent has been set, as it were. And yeah, so that is how it is. But it's not cast in stone as the case may be. Yeah, so we said that once you can institute a fresh action, provided limitation has not expired, and then you also don't have estoppel from some other sources. You know, you can also have estoppel You can have res judicata in some other way, isn't it? You know how res judicata comes about? How do you have res judicata? Where will you be faced with res judicata when you started? And yeah, how does it arise? Estompe per rem judicata, yes, or res judicata, yes.
No.
No.
You need to leave and then
Yes, yes.
you need to plead them.
You need to plead them.
Yes, sir.
So what are the things which should be there so that we can say that you are caught by res judicata? So therefore you cannot go ahead.
You need a deed.
Speak into the mic.
If it's still a deed, the child and the courts that's delivered the judgment.
Only that.
That the matter has already been determined by this court on his case.
Just that something is missing. Yes. Please, res judicata is very important. If you've forgotten, go back and read it again. So we mentioned costs, isn't it? We mentioned costs, and if you look at the 17 reform, it ensures that discontinuance is disciplined in terms of cost. You can discontinue, but the court can impose a cost regime, as we'll be explaining. And not until you paid costs to the defendant, you cannot come back. And the defendant is entitled to costs occasioned by the withdrawal. And there can be taxation of those costs. When I say taxation of those costs, you just jump to order 74. Look at order 74 now. I just want to show you something. Order 74. Order 74. Order 74 rule 2. Or maybe start order 74 rule 1, 2. In any case, where the court considers free to award costs on any party, the court may by order direct taxation of the cost of the party and payment or direct payment of the sum in lieu of the tax cost. So when it comes to costs, two ways. We have a court which are just awarded by discretion of the court. The court will just say that cost of so much without going into any specifics. We also have costs which are actually taxed or which are assessed by the court, in which case the court will need to take necessary evidence. So if you look at the 74 rule 2, go to 74 rule 2, assessment of cost by the court. The amount of cost to be awarded shall be assessed by the court. 2, before any assessment, the parties or their lawyers may briefly address the court on question of costs. And then it goes on to 3. Without prejudice to the powers and discretion of the court, an award of costs shall be designed to compensate for expenses reasonably incurred and court fees paid by the party in whose favor the award is made, and B, provide reasonable remuneration for the lawyer of that party in respect of work done by the lawyer. Then you go to 4, certain parameters are provided. In assessing the amount of costs to be awarded to any party, the court may have regard to A, the amount of expenses, including travel expenses, reasonably incurred by that party or that party's lawyer, or both in relation to the proceedings. B, amount of court fees paid by any party. C, the length and complexity of the proceedings. D, the conduct of the parties and their lawyers during the proceedings. And E, any previous order as to costs made in the proceedings. So the court can summarily determine the cost on its own and then just make some determination. Or the court may even appoint a taxing officer, either a registrar or any appropriate person, to take the evidence in terms of receipts and other things from the parties to now determine how much cost is worthy, having regard to the circumstances. Then the court will now make an order based upon that. So that is a taxation or assessment of cost. So where you discontinue, as it were, the cost will be awarded, and the cost can be either by summary determination by the court or by assessment or taxation, as we have just seen. But let me ask this: why do you think that people like to even discontinue? Essentially, without the leave. Discontinuance without the leave. What could be the rationale? It may be a litigation strategy. Maybe, for example, the plaintiff discovers that it's the wrong course of action, which has initiated. To not even wait for them to go through the process. Or there was a misjoinder. That maybe like the plaintiff actually sued the wrong person. Or maybe some jurisdictional defects. You realize that the court didn't have a jurisdiction. So you don't want to wait for you to be slapped in the face. As they say that a slap which is meant for you. Yes. Or sometimes too, a plaintiff may anticipate a defeat in a pending application. Either he wants to avoid a binding dismissal. There's a problem. So if you wait and your opponent should take it up, that your matter should even be dismissed or some other way or choose. And then the court, for example, agrees. That may serve as what? A stopper. Now, discontinuance would leave, yes.
Please, with this one, can people say that if the plaintiff should assess the cost that will be incurred during the litigation period to the damages that will be awarded, maybe the cost will be more than that, the damages, so we want to discontinue. So that also be a factor.
Ordinarily, it's not common for cost to be more than damages, unless the case was really not a case which should be pursued before you get the cost exceeding the quantum of them. But it's not impossible, it's possible, but it's not common, as it were. So because you'll be discussing the issues around it, if there's any particular question that you want to ask. But just one thing that in order to bring, I look at Mr. Kwame tells me, I ask you to go and read, you don't read. So that is why I have to read for you. So let's say filtering about discontinuance would leave. Drawing upon this rich discussion. So when it comes to discontinuance with leave, here we have actually moved from the party's autonomy to judicial or supervision. The plaintiff is no longer a master of his actions. It's not the dominus what? Litis. So it's a litigant who has invoked the machinery of justice, engaged the defendant's rights, and consumed judicial resources, as we've seen. So that withdrawal becomes conditional and not automatic. So when does leave become necessary then? As we've said, where the defendant has served signal the defense, and the plaintiff has taken a further step in what? In the proceedings. At this stage, issues are said to be joined. The defendant may have disclosed defenses because he filed a signal defense, you've seen his defenses. Or counterclaims might have been raised. So what is the scope of the court's discretion in dealing with requests for leave to discontinue or withdraw? If we look at Order 17 Rule 2.3 as we read, we are told that the court may grant leave upon such terms as to cost and as to any other action as the court thinks for fit. So the phrase any other action means that the court has a lot of room when it comes to making a determination as to whether leave should be granted or not. So it gives the court the power, Mr. Kwame Tetes would rightly so, one, to impose costs, to stay future proceedings, deny liberty to bring a fresh action. So that is your question, deny liberty to bring a fresh action. 4, expressly bar re-litigation, that to prevent re-litigation. Or give a conditional leave upon undertakings. You can be given leave, but certain undertakings will have to be made. So the court has a wide supervisory powers as far as leave to discontinue or withdraw, as it were, may be concerned. But if you read authorities, first Star newspaper, Amuako against Kwan, and all those cases, what we distill is that the more advanced the proceedings, if the proceedings have reached a higher stage, the stronger the case for imposing terms. Just imagine that trial is even ongoing and bring application and say that no, you want to discontinue the case or want to withdraw, as it were. So the court will have to slap you with the stringent terms. And then the court will also have to find out or scrutinize your motive. What is your motive for wanting to discontinue at this stage? When everything is going on in the trial, why do you want to discontinue? You can even get people who may want to withdraw on the eve of judgment. It's possible, it's their right, but of course, as whether that will be granted or not is another thing. Now, in terms of the defendant's prejudice, the court will have to find out that the defendant does not have to suffer any prejudice. And how will the court determine this? The court must consider that costs already incurred by the defendant, damage to the reputation of the defendant, any tactical disadvantages in terms of maybe the defendant having a certain defense, and because the plaintiff wants to actually disarm him, try to discontinue. So the court will have to look at all that. And also duplication of proceedings. Yes.
The statement you just made before this, that the parties may be want to withdraw. That parties may even want to withdraw just before judgment. So if the court does not grant them the leave to withdraw,
We discontinue.
to discontinue, after judgment, can they decide not to enforce the judgments down?
Oh, there's also got a compromise of judgment. See, two things. It is one thing for the court to give a judgment, another thing for the judgment to be executed. It's not the business of the court to police whether you enforce the judgment or not. The court is there to make adjudication, determine whose interests have been violated, whose right has been violated, who's in the wrong, who's in the right. That is the business of the court. But when that is determined, as to whether you would like to implement it or not, it's your decision. And people can even compromise judgment. People can even litigate at Supreme Court and still compromise judgment and say that yes, This is what the court have said. But we have reached amicable understanding. We are not going to go by the straight terms of the judgment. But if it's a judgment in rem, there is a different thing. Let's say the judgment affecting land. It's not just only about the two of you. It also is a notice to the world, to the whole world as well. Yes.
Thank you. So in a situation where the plaintiff has applied for discontinuance or
Yes.
withdrawal with leave, and same has been granted, but at the time the defendant has filed defense and counterclaim, will the counterclaim still continue?
Yes. Because the counterclaim is independent or separate action. So plaintiff, if you have withdrawn or discontinued your claim, the defendant counterclaim will continue as it were. Now, when will leave be refused? When will the court refuse leave? That if you want leave to discontinue, when will the court refuse it? So the court will refuse leave where a prima facie defense has been demonstrated. The court looks at the pleadings and say that, assuming what the defendant is saying is true, is an answer to the claim that you have made. Then the court may refuse the leave for you to discontinue. So you are running away from judgment. Or two, where the action appears vexatious. That is to say that the court looks at it, and this particular case, you are just using it to persecute or to harass your opponent. You will not be allowed to discontinue. The court will let you, because there's a need for finality. If you are not given the leave to discontinue, you'll be forced to prosecute to the end. And then there will be determination. And that will bring about finality. And that will cure the vexation that you are trying to do. And four, three, where there is a lis alibi pendens, the court will refuse leave. Remember lis alibi pendens doctrine? Not the alibi in criminal law, but lis alibi pendens in civil litigation. Yes. Yes. You will explain it for us. Lis alibi pendens. Where's the class reader? She's missing. She's sit over there. Where is she? She's going for a funeral. Yeah.
There's already a similar matter with the same facts and the same parties that is pending in another court's jurisdiction.
Okay, good. Yeah, so where that is the case, the court may refuse the leave. Because if you have a lis alibi pendens, it's not for discontinue. You have to stay. You have to stay one of what? The actions. So that the other action will about the outcome, or it will have to continue at all. You have to wait until the action in the other court or in the other venue of forum has been determined, as it were. Again, where the plaintiff is seeking to escape statutory consequences, that is why he is seeking leave to discontinue. The court will refuse the leave or may not grant the leave, as the case may be. Now, these points we have conversed actually from the common law, because the statutory framework is still supplemented by the common law, at least from the first Star newspaper case that we discussed. Yes.
The last one,
where the plaintiff seeks to escape statutory consequences. And I want you to read Mr. Kwame Tete. He was my teacher. He taught me civil procedure. Okay, so just before we go, I would like you to think about the cost which we discussed, how the court will use the cost as a way of managing discontinuance, and also imposing terms with respect to either stay or subsequent proceedings. Because you are in a hurry to go, I will say more about that, but I will expect you to now, just before you go, somebody asked a question, counterclaim, discontinuance and counterclaim. I answered it, but all of you need to remember what we discussed earlier on, that counterclaim is essentially a cross action, isn't it? Good. Now, if it is a cross action or a cross claim, as it were, what it means is that where we are discussing discontinuance of the plaintiff's claim, it has implication for the plaintiff's, the defendant's counterclaim. As you notice, if you read Order 17, we don't see anything about counterclaim. We don't see anything there. It's silent, isn't it?
Yeah.
Good. So let's look at these scenarios. The plaintiff discontinues the action. So scenario 1, no counterclaim filed. The action ends. There's no problem. The cost usually will be paid. Scenario 2, counterclaim is filed before discontinuance. So the main claim will end, but the counterclaim remains what? Alive. The defendant may elect to proceed with the counterclaim, and the defendant may, as it were, may become like the plaintiff against the original what? Plaintiff. Although designation will not change, but in substance, that is what it will be. So the court will treat the counterclaim as if it were a standalone action. Now, is leave required to continue a counterclaim? Must you get a leave? Okay. So the mere fact that the plaintiff has withdrawn his claim doesn't mean that the defendant cannot continue. He can continue. He doesn't need what? Leave to continue. Of course, the defendant can also discontinue the counterclaim. You know, can be discontinued. Okay, so for next week, yes.
In the instance where the defendant wants to discontinue the counterclaim, will the same rule apply in this instance?
Yes. Yes. But it's not that for counterclaim, you don't need to enter appearance because it's against the plaintiff, it's already in the matter. So you filed your senior defense and counterclaim. The plaintiff has not yet filed the reply and the defense. And you want to withdraw or discontinue your counterclaim as whether that can be done. Yes? The Order 17 is silent, but by the logic that a counterclaim also operates as it were, like like a claim as the plaintiff has brought, the same principle will also apply. But it's not likely to get a defendant who will want to discontinue his counterclaim against the plaintiff, isn't it? Yeah, so next week, let's read around applications. We've done that already. application affidavit, by the syllable, that's what we're supposed to do next. And then we move on to pre-trial and then protocols. Discoveries, interrogatories, admissions, application for directions, a witness statement, and so on. So we do them quickly so that we do trial and we'll be able to move into execution of judgment. We do execution of judgment, and then we come back and discuss probate and administration of the 66 before we look at some other things.